The number one concern we hear from clients after a DVO has been made is, how does my domestic violence order affect parenting orders and child custody? A parenting order is an order issued by the Federal Circuit Court or the Family Court, which sets out the parenting arrangements for your children. Parenting orders are legally enforceable. Penalties apply for parties who are found by the court to have contravened parenting orders without a reasonable excuse for doing so. Those penalties can range from make-up time to cost orders and even imprisonment. A domestic violence order, which is also known as a protection order, is an order made in the magistrate's court upon application to the court by an aggrieved party who has been a victim of domestic violence. A domestic violence order or a protection order will be made where 1. There is a relevant relationship between the parties, 2. An act of domestic violence is found to have occurred, and 3. Where the court determines that an order is necessary or desirable to protect the aggrieved from the perpetrator of that violence. Domestic violence includes physical abuse, verbal abuse, intimidation, harassment, threats, and coercive and controlling behaviour. Protection orders can include various conditions, including that the respondent be of good behaviour and not commit domestic violence, or the terms can be more rigid so as to prevent the respondent from having any contact with the victim. If a person does not comply with the terms of a protection order, the breach may be reported to police and they may be charged with a criminal offence. If a person is found guilty of breaching a protection order, the penalties can be severe and can include imprisonment. You should speak to your lawyer about the best way to communicate with your former partner about the care of your children, so as to ensure that you are not in breach of the terms of the protection order. If a protection order is made by consent without any admission, meaning you don't agree to the allegations being made against you, it is unlikely that the protection order will have any significant effect on the time you spend with your children, as ordered by the court, unless the aggrieved is alleging that the children are at a risk of harm in your care. The court may, however, determine that it is appropriate to make parenting orders that are consistent with the protection order to deal with any safety concerns of the aggrieved if they were to come into contact with you. For example, by making orders that changeover occur at a public place. If a protection order is made after a hearing and findings of fact are made by the magistrate that you committed acts of domestic violence towards the aggrieved, then the family law courts may take those findings into account, and this may have an impact on the outcome of your parenting case. Where there is a protection order and a parenting order, the parenting order overrides the protection order to the extent that the parenting order is inconsistent with it. However, the magistrate's court does have the power to suspend or vary part of a family court order if it is deemed necessary to protect the aggrieved. Therefore, if you are a victim of an incident of domestic violence which has occurred after parenting orders are made, and you believe that those orders are no longer in your children's best interests, you should file an application for a protection order and seek a temporary protection order that suspends or varies the current parenting order. For example, you might seek that changeover happen at a public place. And you should file an application to change your parenting orders. Prior to taking these steps, you should seek legal advice from an experienced family lawyer about your individual circumstances and the requirements you must satisfy before your parenting order can be changed.